right, hello again. This is Ben Hitchcock Cross talking to you today. We are got two things that I want to talk about. Number one, I want to talk about these videos that we're putting out here. Just sort of set that up, give a little explanation. And number two, I want to talk about some recent victories at the ERD, and we've got them to follow the law 3 times in 3 weeks. And they didn't want to do that. So I think that's what we'll finish up with. I can't wait to talk to you about that. So, starting off, if you don't know, we have found again a hard drive with quite a few hours of hundreds of gigabytes, at least, of videos. Some of them, like going back to 2022. So you will see that some of what we're starting out with, at least, is pandemic, post-pandemic related. So something to keep in mind. Why are we showing these? So here's I think the format that we're going to try to do. I'm trying to break them out into hour-long segments. We'll see how that works. We get them basically in 4-hour chunks. So like the hearing that we're watching right now from a UWM person, I think there's four 4 hour chunk. I mean, I think we're like 4 hours is quarter of the way through. So I guess we got to keep that in mind. I hear what people are saying about speeding things up and editing them. If I see enormous blocks of gaps when I throw the thing up there, I will try to cut those out. But in general, we'll try to be clear. I also will try to keep a witness as in their own separate section here. I do think the witnesses are going to be the most fascinating thing that we're going to see here. But the whole point of this is to see how the DWDERD, the Wisconsin Employment Rights Division, works and their work, and to have justice be seen and be heard. So there's no doubt about it that this is going to be seen as an attack on them, and I cannot underscore enough how exhausting it is to hear public servants complain about having their public work contained on public documents be shown to the public. Why they think that is not okay in America, I just don't get it. But there's no doubt that either secretly or not so secretly that will be communicated, and that's okay. This is a news service. That's what we do here. It will be directed a lot at me, and that's okay too. And we'll get into the second part of that because I don't need the ERD to be friendly with me. I sure like to be professional. I sure like to work with them. But the main number one thing that our relationship needs to have, the number one priority, is for them to follow the law. Same for me. So I think that's the thing there. And when time and time again we come up to them seeming to do whatever they want, that we need some scrutiny, democratic scrutiny. So that's good or bad. Please put your comments up. Seriously, let's do that a little bit more, and will give us a little, us here, a little bit more feedback on what kinds of ones that you want to see and which ones you don't, and so forth. I thought this UWM one is valuable and insightful because it's UWM, and we've seen some of their work before. But it's the state of Wisconsin, so that's what draw my particular interest about it. But believe me, we've got banks, we've got movie theaters, we've got a lot of different employers. So let's go. I want to say on that, it's our goal, and I know I've said this many times, but we are trying to find hopefully one other guest host. I don't know, something like that. We're trying to get 3 people, including Debbie and I, to sort of comment on these, hopefully in a live, hopefully Thursday nights after 6. That's what we're working on, and I'll keep you apprised of that. So appreciate it. Definitely give us a thought in the chat, comments at least, if that's how you feel about that. Okay, moving on. And we'll break this out into plenty other things, but this is sort of just underscoring what we're talking about before. 3 times in 3 weeks now, we've got the DWD to follow the law, and they didn't want to do that. So the number one, um, if you'll recall, on the Teresa Falderon versus MPS case, all of the ALJs except Laura Amundsen had recused themselves because Calvin Furman is a witness. The ALJ, Judge Calvin Furman, is a witness in that case. So that everybody recused themselves except for Laura Amundsen, and Laura Amundsen doesn't do in-person hearings. Okay, so that's and the reason she didn't recuse herself is because she said this was an in-person hearing. I instruct you to do in-person hearings, so, or I don't do in-person hearings. She may have perfectly legitimate reasons. Again, we've discussed that. I don't. Well, I do know now because she said it. But the point is that the DWD knows that she doesn't do in-person hearings. They also knew that this case was going to be in person, and she had already removed herself from it. They assigned it to her anyway. So I'm sure she wasn't feeling that happy about being assigned this case, and in fact, she insisted that it had to be online. And so when we pointed out that that's not happening, we also pointed out the numerous amounts of bias. We're going to read our motion in that because I think it lays bare quite a few things about the ERD and probably also gets into why they're could be following the law this week as opposed to some other times. But hey, we always support course correction here. Always, 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 always. No matter what the motivations behind it. So then we let's say like this. This is Judge Amundsen, put the whole case in abeyance because she said that it needed to be consolidated with this other case, and we said you don't have any ability to do that, and she said, well, I'm doing it anyway because of administrative efficiency. So then we, in desperation, because we knew the other case, the main case was never going to get heard then, because investigations could take 8 months, easy, and they know that. Especially, let's just look at the Garcia Hoven one that took 2.5 years, I think, and certainly didn't come out to the last day of his other hearing, which was really outrageous. Really outrageous. It's hard to believe that didn't happen on purpose. So she puts this thing in consolidation, deep sixes it. We're sitting there, and we have no choice but to withdraw the complaint. But we don't withdraw the complaint for fun. We withdraw it under protest. By the way, we've appealed their dismissal of the case because, again, it was under protest. We didn't withdraw because we wanted to. We withdraw because this judge was refusing to hear the case and refusing to address the real issues here, of bias. And the key thing is, before you consolidate a case, you got to talk about bias, especially if the parties are asking you to talk about bias, because bias is fundamental and it's due process, and if you're biased, you can't be making decisions about consolidation. That's what the problem was, and lo and behold, she admitted that she was biased after that fact. So, going back to issue number 1, the DWD, this is the investigators, refused to accept the withdrawal of the retaliation complaint, even though it was in writing and signed. And guess what? They backed down on that one when we told them what the law was. Took some time, but that's what we did. I think they violated my client's First Amendment rights in the whole process. But hey, we'll see how that works out for them. Then, number 2, we're on the Department of Workforce Development. Let's say they assigned another case to Laura Amundsen and another MPS case to her, and that case is going to be held in person. Because what is our rule? The rule is that unless both parties agree, the thing will be held in person. Bam. And guess what they did is try the old chestnut, the old worked gag, that the parties, need to come up with some positive reason. And she tried this again. Okay, what's your reason? And we said, hey, look, It's just there's the statute and nothing else, and it's our right to have a hearing in person. And if you're not able to do that, I understand, but we need to have that in person. So that ended everything, and my client got prejudiced because before asking, they should have asked people before assigning them an ALJ who cannot hear cases in person if they want to have an in person hearing. But they didn't do that, and now we have to start the whole process all over again. Number 3, the ALJ in the Stolar case, ALJ Benitez Morgan got a motion from her boss, Amy Petchacek, stating that, among other things, that our subpoena to her was defective and bad, and we're a bunch of jerks, and we did a bunch of mean, nasty things to her. Okay? And again, we're trying to get the head of the Department of Workforce Development to appear for a deposition, which she's refused to do on several occasions, because she was involved in the investigation into the Stolar case. And her response is, I wrote an affidavit saying I don't know anything about Stolar or the cases or anything else. Which is kind of hard to believe because, as we have heard from Chrissy Preston and Carrie Beyer, that they reported to the cabinet, and when you find out who that means, it means Amy Petchacek and Kevin Carr. So, whereas Alice Delau, and I forgot about this because it's come up because they've now complained about it. But let's remember when Alice Delau wrote her decisions on the Novak case, how she was at extreme pains to put it as my fault that she said nothing about the Amy Petchacek. And what did she do? She put on the record that Amy Petchacek doesn't have anything to do with the case. Same thing, Benitez Morgan put the same thing on the record, made the same decision that she's not biased because the judge has decided that, on her own evidence, that Amy Petchacek doesn't have anything to do with the case. So, of course, we should have the opportunity then, by law, to cross-examine Amy Petchacek to determine whether she has anything to do with the case, but they're not going for that. Because in this administrative system, the judges apparently feel that they can just say what the facts are, and that's it. Nobody has an opportunity to respond. So, in fact, they can say your evidence is wrong and you're a liar, and you don't have an opportunity to cross-examine their evidence. And so that's not really the American system. That's not how that works. Judges don't get to create evidence. The parties put evidence before them. In the ERD, judges, hearing officials can look at other data, memorandum stuff, but they have to disclose it to the parties, and the parties get the opportunity to rebut. They don't do that there. They just create their own data and say, hey, we say that Amy Petchacek doesn't involve herself in this case. Well, that's a problem. So this time, Benitez Morgan took it a step further, and she said, I believe everything that they wrote in the thing, and you don't get to respond because they said your affidavit is wrong, and so therefore, by these rules, you forfeit the right to respond. I mean, it was pretty clear. And so we said, hey, it's a little thing called due process, and by the way, there's a specific rule that says we get to respond. So I don't know where you're coming up with that, but hey, this is a big problem, and it's evidence of bias because you have, without hearing from one side, you've made a decision, and that's what you call evidence of being wedded to a particular outcome. We sent that to all of the Wisconsin employment lawyers in the group, many of which couldn't handle it. Totally understand their point of view here. Maybe they can understand my point of view, which is uh, Benitez Morgan immediately said, "You must have misunderstood what I said. You obviously have a chance to respond within 2 weeks now, and I'm going to put a deadline for that." So, employment lawyers, you may want to think before you act, because we already won. Is the point? That's 3 times in 3 weeks that the ALJs followed the. They were made to follow the law, but they followed the law. So that I think is a pretty big watershed moment here, at least for my work going forward. We are very pleased with that, and I think the outcome for um, the clients will be uniformly better. I don't mind if they hate me, if that's an outcome. What I do mind is their refusal to follow the law. And so that's what, you know, um, people in the Employment Lawyers Association, for example, said you should stop bashing the ALJs. And I'm going to be really clear that it's telling hearing examiners that they need to examine hearings according to the law is not bashing them. It just isn't. And I can do better than that. What that is requiring a constitutional fair hearing. That's precisely what that is. And that's not only an advocate's job, it's everybody's job. And I don't just mean the tribunal, I don't just mean the tribunal supervisors and the lawyers on the other side. And everybody in here at this channel, I think, knows that. It's all of our jobs in a democratic society to make sure the courts work and even the quasi judicial tribunals are working properly and under democratic scrutiny. So, um, I'll just close with this. We had a hearing with Benitez Morgan this last week, and at that hearing, 5 people showed up in support of the complainant and against really what they were trying to do um, there. To really, it's the state of Wisconsin, as I've said, in my opinion, is acting. We're not getting a fair tribunal because we're going against the state of Wisconsin. We don't really get a fair tribunal. I think that's part of what's being shown in this UWM one. They can't chill employers' rights. I think we're getting that sense there that the ERD does not feel that it and does not act in a way to supervise or enforce the Wisconsin Fair Employment Act against the state of Wisconsin. I think that, or other local governments, but particularly MPS, for example. So, hey, even John, you know what even happened this week? John Gelhard communicated with me when after I sent him an email after he told me he would never do that. He did mail me something, but hey, so maybe we'll put that on the 4 for 4. I don't know, but let's keep on moving. I mean, I just do some closing music to make one feel like one's closing. I don't think in a democratic society that anybody should feel the need to apologize for requiring the government to follow its laws.